You're listening to Secure Your Creations podcast, where innovation meets legal protection. Hosted by IP attorney Mario Milano. This show cuts through the legal noise and offers real insights to protect your patents, trademarks, copyrights, and trade secrets. Whether you're an inventor, entrepreneur, or business leader, we help protect what you've built. Capitalize on your creations and stay one step ahead of the competition. Welcome to Secure Your Creations podcast. Let's get started.
And yes, let's get started. I'm Craig Andrews, and welcome to Secure Your Creations podcast with our host, Mario Milano. How are you doing today, Mario?
I'm good, Craig. How are you?
I'm not doing too bad. So you offer a lot of services as an IP attorney, patents, trademarks, copyright, and trade secrets. But today we're going to focus on trademarks. How do you feel about that?
Excited. Always like to talk about brand protection.
There you go. So trademarks, let's start with the basics, get everybody familiar who's listening. What is a trademark by your definition?
Yes, a trademark is something that protects and excludes others from, it identifies the source of a good or a product or service, and the trademark prevents other people from using that name in a way that would cause confusion in the marketplace.
And so a lot of times we work in marketing, and a lot of times what happens is people go, I got a really cool logo. And, I think it's really cool. I should put it out there. But what you're saying is that you really should consider doing a trademark search, correct?
Absolutely. Because it's not just, are you copying somebody else's mark exactly? But is it similar enough that an ordinary consumer in the marketplace would be confused and think that two things are the same? For example, if it's a relatively inexpensive item, maybe something that costs $5 or less, you see, there's that brand uses a red and blue circle. It's kind of, they just pay a little bit of attention to it. Well, now if you come up with a pink and blue circle for the same product, people aren't going to be paying much attention, aren't going to be examining that closely, but just glancing at it, they might think, oh, this is from the same producer or the same source, and that would be considered infringement.
And a lot of times in marketing, we're talking about making sure you can create your uniqueness or be different. And a lot of times in your trademarking, that's a key part to it. So we hear a lot in terms of, I have a logo, I have a color, I have a song or music that can be trademarked. What's the wildest thing that you've actually had to ever trademark that you can think of?
Yeah, the sound is always an interesting one. They're kind of tough to get because you have to show that people identify that as your source of, as being, that people associate that with you. So, they're a little bit tricky to get, but, also fun because it's a little bit out of the ordinary. And those are the ones that I like to see. Then you hear about ones that are, scent. I've seen people apply for that as well. That gets pretty tricky, but, they are fun to work on.
So I can imagine there's a lot of challenges. And as we move to the next segment here, what I want to do is not just make this seem so easy, just apply for a trademark and then it's just that simple and boom, you have it. Let's talk about some of the hidden sides, the things behind the scenes that might have to happen from an IP attorney that comes from trademarking. So from an outside perspective, what type of paperwork, what's the process in terms of developing a trademark?
Yeah, as you mentioned, I certainly recommend that we do a search first. That'll make sure nobody else is using that mark. So, if we do the search, and then I say, okay, it looks good. We think this will go right through. Typically, that's the way that it does go. That we can get the application right through. So we do the search. It usually takes a couple days to a couple weeks. Then we select the goods that you're going to be doing. The interesting thing about trademarks is you don't just apply for one trademark. You apply for it in certain classes. So we decide which classes you're going to be entering based on the types of goods and services that you offer. Then we submit the trademark application. Once we submit it, it typically takes a couple months, about 8 months right now, until we hear back from the trademark office. If everything looks good, the trademark will be published. Sometimes the trademark office will want to see some changes to the application, maybe the description of the goods or maybe the specimen that we submitted. They might have questions about that. Then once it's all in order, the trademark gets published. That gives any of your competitors or other people who might be interested in the mark That gives them 30 days to oppose it if they would like to. If no opposition is filed, then we'll get either a notice of allowance or the mark will then be registered.
Wow. So let's talk about the other side. You go through all that work. Have you ever had to tell someone that they could not get the trademark? How does that process work?
Yeah, I have seen that happen sometimes. Typically that only happens when we don't do a search before we file the trademark application, because we're pretty good at identifying, these things are going to be problematic, whether they will be a problem or not. Sometimes we do the search. We say, look, it's going to be tough, but we make the decision anyway to move forward. So the trademark office will sometimes reject your application, and they'll say, there's a likelihood of confusion with this other mark. And then we respond to it. We point out reasons as to why our mark is different from what's already out there, and show why, and discuss why the ordinary consumer would not be confused, as there wouldn't be any confusion between our mark and the mark that's been cited.
That makes sense. So the other side, let's talk about the enforcement of it, right? So that's one of the advantages of having the trademark, is to make sure that your brand or whatever it might be is separated. Tell me about what the process is in terms of the enforcement generally.
Yeah, trademarks are interesting in that you do need to actively police use of your mark and make sure that nobody else is infringing upon your trademark. Otherwise, it's considered to be generic, and then you could lose your trademark. So we have different watch services that we utilize to see is anybody offering anything on the internet or anywhere else in the marketplace that would be likely to cause confusion. If we do identify somebody, we typically start out by just sending a cease and desist letter. They don't have to be mean ones. Some of my favorite examples are when Budweiser needs to enforce their trademarks, sometimes they'll send like a town crier to the accused infringer's office, and have fun with it, but at the same time let other people know that, look, this is our trademark. We need to police this, otherwise we'll lose the trademark. So we're not trying to be bullies or anything. We're just doing what we need to do to make sure that our trademark stays intact, and telling the other side to cease use of their trademark. If the other side complies, then everybody's friendly, and it just goes away. If the other side digs in their heels a little bit, then that's when it can start to get towards litigation.
Wow. So that actually brings up a big point you brought up in terms of Budweiser, was it?
Yeah.
Okay. So in terms of Budweiser, they're a big boy, right? So imagine one of the things that I know that you advise on is get that trademark work done early, even in startups. So let's talk about startups who have a new brand, a new identity of some fashion. Start the foundation well. Let's talk about that a little bit.
Yeah. So when you're a startup, you're going to be spending your time and effort on marketing. You're going to start to develop your brand name, your logo. The thing you don't want to happen is to, 6 or 8 months down the road, turn around and redo all those efforts again, because either you're unable to get your trademark, or, you find out that somebody else already has a trademark for the same thing. So that's why the search is so important. You certainly want to start out doing the search yourself, but the trademark attorney like myself would be able to identify and have a more familiarity with the subject matter, so that we can usually have a pretty good idea of whether something would be considered infringing or not, or likely to cause a confusion. And so you do the search early, make sure that everything's good to go, then submit your trademark application, and then you don't have to worry about it. You don't have to worry about somebody coming down a year later and telling you to stop use of your mark. You'll have your trademark that lets everybody know that, this is yours and nobody else can infringe it.
Now, the funny thing is, I know we're both sports fans, right? And so having kids who came up in the sports fields and things of that fashion, we always talk about do the work early.
Yeah.
Do the work early so it won't hurt you later. And the same thing I think applies to this in terms of doing the search. There's a big thing that people like to escape that process, but that process that you're an expert in allows people to be able to move forward more efficiently down the line. We used to have a saying that was fast is slow and slow is fast. And so if you do it right the first time, then down the line, you're going to sprint as fast as you can. But it's nothing like getting caught from behind on a small detail that you didn't quite fix in advance. That's always kind of nerve-wracking, I can imagine, especially when it comes to trademarks and so forth. In terms of rebrands, So let's say a scenario of a company goes, okay, we've been in business for 20 years now, and it's time for us to rebrand. What's your advice in terms of rebranding?
Yeah, I would say, take an approach like you would just as if it was the initial branding effort. Start out with the search, make sure that that's good, and then start to file trademark applications. Make sure that nobody else is in your market space. Depending on how drastic the change is, sometimes it can be difficult to get the trademarks in place. Other times, if it's just small changes to your logo or something like that, it's not as difficult, but we still want to file those trademark applications to make sure that we can keep others away from your marks in the marketplace.
So I know you do patent law as well. And a lot of times you talk about having a patent portfolio. Is there such thing as a trademark portfolio?
Absolutely. Yeah. So, a lot of times you'll see a company with their logo. It'll have some type of design in there, as well as some words or maybe a tagline. So we can protect the tagline on its own, and then we can protect the logo as well. And the logo, sometimes it'll be just the image or the design that's associated with it. And other times we'll do a trademark for the logo image as well as the words all in one. And so having multiple avenues like that, multiple forms of protection just helps keep everybody away.
And jingles, I know we talked sound before, jingles and things like that all would fit in there.
Oh yeah. We can add those in as well. Like I said, the jingles aren't as common, but if you have them, if you're doing marketing like radio, TV, or even on the internet, any type of ad where you have sound associated with it and you're consistently using the same type of sound, then yeah, that's certainly something that we can protect as well.
So just for clarity, trademarks are different than copyrights. Explain the difference, especially when it comes to the branding and stuff that we're referencing.
Sure. Yeah. So copyrights are more for an artistic creation. We typically see that more for, a book or a painting, a song. And a copyright doesn't necessarily need to indicate the source of a good. It's just you have a work of art that's in a fixed, tangible medium. Where for a trademark, then it's more used as a source to identify the good. So if you had a single book, you would probably get a copyright on that. But if you had multiple books and, you use the same title every time so that now people associate that, this book is, Harry Potter, you can get a trademark of that because there's been so many of those books.
Wow. So it is a fine line, which is why, as you're listening, you should have an expert that can help you delineate between that. Has there ever been situations where people tried to file for a copyright when they really needed a trademark?
Yeah, I do see that sometimes. And, it's just there's different avenues of protection, different protections that are offered. For a copyright, you kind of have to copyright to show infringement that it would have to be basically a direct copying of it. Whereas trademarks are a little bit broader. It's not just that it's a direct copy. It's just they're similar enough that there would be confusion as to the source of the goods. So, if you file for a copyright, you're kind of limiting yourself as to the scope of protection that you're getting. So, if you're trying to protect your company, then you should go for a trademark.
So to kind of tie into Milano IP as well, the thing I want you to talk about here a little bit is the DIYers. Okay, so I'm sure you've had your fair share of conversations with DIYers, and I'm sure that things may have worked and may not have. But let's talk a little bit deeper about the importance of having an IP attorney who can really do the work for you thoroughly.
Yeah, the common thing that I see with people who want to file the trademarks themselves, they might skimp on the search, or they just don't know how to do the search. They don't know what the examiners are going to be looking for when they're examining the trademark application. So, to them, they do a search and they say, oh, well, I didn't see anybody with the same exact thing. Or sometimes they think, oh, well, if I just change the spelling, maybe instead of saying SKOOL, SCHOOL, I'll just use SKOOL. And, misspellings that's not enough to get you around somebody else's trademark. The examiner will still say that there's going to be a likelihood of confusion. The spelling won't help. And so that's one of the common mistakes that I see from people who try to file the trademarks themselves. The other thing is just selecting the goods and services that you're offering. There's a long list at the trademark office of pre-approved descriptions of the goods. And so sometimes people will limit themselves. Either they'll overreach and start to put in things that aren't really applicable to their business, or they'll not include enough because they're offering additional products that, maybe they just forgot to list. So sometimes the scope of protection that they're seeking isn't correct, but they don't actually know that because this might be their first time filing a trademark application.
So let's talk a little bigger as well. I remember in one of our other podcast episodes, we talked about in terms of pharmaceuticals and all the products that they have and kind of having a unique name to it. Talk about, do they have trademark scenarios when it comes to their new brands? I've seen some names out there that don't even make any sense, but I know you talked about that. Go ahead. Why don't you explain?
Yeah. So you want to trademark not only your company name, but also your product names as well. If you're going to have a line of products all under a certain name, then, we want to trademark that name because that's going to help the consumers in the public identify the source of the goods. And so we do see sometimes these made up names that people have never heard before, but actually those are the easiest ones to get a trademark on. I typically tell people, if you make up a word that's not in the English language, that's not in the dictionary, the odds of us being able to get a trademark on that are very high because, there's just nothing else like that out there.
So speaking of pharmaceuticals, because they do a lot of international work in a lot of cases, does a trademark extend internationally?
No. So just like for patents or other types of intellectual property protection, if you file for a trademark in the United States, that's your protection is limited to the United States. Almost every country out there has, they have their own trademark laws. And so there is protection available in the other countries, but you do have to seek out protection in each individual country.
Okay. I didn't realize that, but that's good to know. And so if you had tips that you could leave to the audience in terms of trademark, what is the most important 3 tips that you can give to them?
Yeah, the most important one is do the search early. As soon as you're starting to brainstorm ideas for the new company name or logo or product line, start doing the search then. We can usually do a search, a couple of names all at once and just bundle it all together. Once we do the search, then, of course, file the trademark application early as well. It takes a couple months for the trademark application to go through and get processed. So the earlier you can get started with that, the better. And then the last tip would be, make sure that you're enforcing your trademark once you get it. Make sure you're looking around. It doesn't have to be every day, but, there should be a regular review of the marketplace and making sure that nobody else is using anything that would be likely to cause confusion with your trademark.
Awesome news, awesome information. And if everyone's listening, understand there's a difference between going to a professional and doing it yourself. There's an ROI perspective to it. When you think about the time and money and effort spent, that may not, we always say a lot, where do you spend your money? Do you spend it at the beginning and know you're secure all the way through the journey? Or do you just go, let's just get started going and then we'll figure out those problems at the end? Usually the number accumulates pretty big by the time you get down to that end of that road in which maybe somebody else. Let's talk real quick before we do our segment of, is it patentable? What happens if you don't trademark it and somebody else who finds it first ends up, or something similar is happening down the line? Talk about that a little bit. I know that sometimes people go, oh, I've had this since 1932, but they never trademarked it. What does that mean to them?
Yeah. So for that, if you started using your trademark or your name or, whatever your mark is, if you started using that before somebody else applied for their trademark, then ultimately you will have rights to use the same mark that you've been using. But it gets to be an expensive process because you need to show that you've been using it consistently throughout the entire time, and that other people know, or the consuming public knows that you've been using the mark. And so what would be relatively inexpensive to file for the trademark application and just have it on file and let everybody know that you're using it, now it becomes a pretty expensive thing, because you can imagine that if somebody else is using that mark, they want to use the mark. So now they're getting their attorneys involved to try to show that you have not been consistently using the mark and that they should have superior rights to it. And now you have to get an attorney involved to go through the litigation process and show that you have been using it correctly.
So even more of a point in the beginning of the journey, as soon as you can, do the search, hire an attorney who can give you the information that you need so you don't have those back end problems down the line. So we're moving now into our normal segment that we do every episode, which is it patentable? Mario brings together a lot of different ideas that might be sitting out there in the realm of different ideas. And it's amazing kind of things that come up in terms of things that are patented. I know you've talked to a lot of clients and a lot of things about products, but the one that we're bringing to the stage today is this one, which looks like a dog collar of some fashion to me.
Yeah, so this one is a like a thunder blanket for a dog. You can imagine when a lot of dogs, when there's a thunderstorm outside, they start to get nervous. And when you're home and you're with your dog, you can hug your dog and let them know that everything's okay. But if you're going to be going out, maybe nobody's there. The dog might be by themselves. They start to get very anxious. And so this is a wrap that goes around the dog gives them basically a hug, that lets the dog know that everything's okay. And you put it on the dog and just leave it on them until you can get home and reassure them by yourself. This one was patentable. They talk about the different flaps, the types of wrap that goes around the dog, and ultimately they were awarded a patent for it.
Very cool. Very cool. So again, there's all types of ideas out there and everyone has ideas, but are they actually taking the steps to getting it patented? In this episode case, are they getting it trademarked? A lot of that stuff becomes very important, especially if it takes off. We've all seen Shark Tank and things like that. And one of the first questions they ask is, do you have a patent on it? Right? So think about that when you're really bringing products to the market and you really want to push this product forward the way you want to. It also becomes another great asset that you can use when you decide to sell the product. And that all of a sudden becomes much more valuable to your bottom line. Do you have any last words to say about that?
Yeah, I think that's sometimes an overlooked asset of a company is that, not only do they have great products and they have great sales, but they also have their intellectual property in order to make sure that nobody else is able to use their stuff. And from a person who's looking to acquire the company, they want to make sure that, that whoever's selling them the company isn't going to be able to turn around and open up a new shop. But if you have the rights to the trademark, then they know that not only can they exclude everybody else, they can exclude the seller as well.
And actually, to wrap this whole thing up in a nice little bun, you have a product like that you would have a patent on, and then you would trademark the brand. Yes.
Yeah.
Okay. And then any marketing you do around it in terms of slogans or anything else would all be nice packaged into one big package for them. Would that be a safe assumption?
Yeah, absolutely. Yeah. And, if you're looking to sell the company, then we say, look, this is all the intellectual property that we have around this product, patents, trademarks, any copyrights, and then you sell it all.
Beautiful, beautiful, beautiful episode today, Mario. Well, that's the end of our episode. You can find Mario if you have any further questions at Milano IP. If you liked anything that you heard today, don't be afraid to comment, like, share. Mario can be found on LinkedIn and all types of opportunities to get your questions asked. If you have a product or if you have something that you have a question of if it's patentable, send it to us and we'll put it on in front of Mario and see kind of how that works. He'll know better than anyone else will. So again, I'm Craig Andrews, and to finish out, Mario Milano. Mario, we'll talk to you next time.
All right. Thanks, Craig.
All right. Be good now.
Thanks for tuning in to the Secure Your Creations podcast. Make sure to subscribe and follow on YouTube and your favorite podcast app so you never miss an episode. Leave a comment, like, or review. We'd love to hear your thoughts or answer any questions. For more expert legal advice, visit www.milanoip.com. Until next time, is it patentable?